he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for one. It is going to be Zach's last day because he has too much trial experience. They're moving him to intake. So,
No, Judge.
I
won't go.
say nice, be nice, be kind to him. Wish him luck in intake and that he will enjoy it. I always say, roam where you are planted. So we're going to miss you, Zach.
Absolutely. Thank you. I'll miss you too.
All right. Aw. Okay, docket is canceled. All right, so you're filing a motion to withdraw?
That is correct, Your Honor.
Why?
So our client is dissatisfied with the services he received. He's already discontinued payment of the retainer. He's seeking to terminate our services to seek out a new attorney, Your Honor.
All right. So here's the court's issue with your motion to withdraw. How long have you been on this case?
Attorney of record was Anthony Wilson, Your Honor. I can't say exactly how many hearings he's had as the attorney of record.
Ms. Ferguson, when were they the attorney of record?
Seems like it was on March 15th of 2024.
All right, so we're going to start with what has been happening since you've been the attorney since March of 2024.
I was not the attorney of record, Your Honor.
Who was the attorney of record?
Anthony.
This right here is where things start to unravel. Notice how even the attorneys can't keep straight who's actually representing the defendant. One says he's not attorney of record, another says it's the same firm. But Judge Boyd immediately spots the problem. Word salad and excuses. This is a classic courtroom tactic. Delay by confusion. But here's the truth. In criminal cases, a defendant's right to an attorney doesn't mean endless attorney swapping to stall the trial. Do you think this was intentional delay or just pure incompetence? Drop your thoughts in the comments because this mess could cost the defendant big time.
All right.
And he was the one that was hired, but he's with his law firm. Am I correct?
That's correct. He's in the same law firm. So.
All right, so we're doing word salad here, but that's okay. Let me divide this salad up. So April 1st, 2024, it was recalled for April 11th for a plea deadline date, and that was supposed to be the final plea deadline date. On April 11th, the plea deadline date was extended to April 15th because the defense counsel stated they were in Travis County. Even though Travis County starts with a T and not a B, that's where they were. April 15th, it was recalled to April 16th because defense attorney was no-show. April 16th, it was recalled to April 22nd, 2024 because the defense attorney was a no-show. On April 22nd, it was recalled for April 23rd for trial by Judge Angelini. Then on April 23rd, it was recalled again for April 4th by Judge Angelini for a jury trial. Then on July 9th, it was recalled for July 10th for a jury trial. Then on July 15th, it was set for jury trial, September 9th, 2024 for impact court. Then on August 5th, it was set for a motion to withdraw by counsel and defense attorney was a no-show. Motion to withdraw is denied. Y'all need to be in impact for jury trial on September 9th. And they'll bring you overdressed for trial. They'll bring you overdressed in whatever clothing you have at the jail. If you wish to be attired in something different, then you'll need to make arrangements for with your attorney to do a clothing exchange. If there is an issue with the clothing exchange, let the court know, and the court will see if I can help you with that, expedited.
Did you catch that? Judge Boyd just rattled off a laundry list of no-shows, continuances, and delays that go back months. April 11th, April 15th, April 16th, it's like a broken record of excuses. And remember, every reset isn't just a wasted day in court. It's taxpayers' time, jurors' time, and victims' families left hanging. Judges don't take kindly to wasted resources, and you can hear Boyd's frustration boiling just under the surface. Honestly, if you were the judge, would you keep granting these delays? or would you force the trial to go forward? Let me know, because Boyd is clearly done with the stall tactics.
All right, thank you.
And Your Honor, if I may, as Anthony O'Neill Wilson is the attorney of record, no one other than him has access to discovery. He's poorly handled this case. There is no record of him actually ever downloading discovery. It's not like it's in the client's file. Since we are going to be held onto this case, I do ask that it be expedited to put me as attorney of record so I could access the discovery as soon as possible, as early as today.
Right, and my understanding is that your firm, he was with your firm, correct?
Yeah.
All right, so Ms. Ferguson, just make sure that his name is there, but I will tell you, since your firm is listed as the firm, your firm should have access to the discovery. But if you're saying your firm doesn't, which I find that hard to believe, since the previous attorney was a member of your firm, we will make sure that that happens. But a motion for continuance will not be granted because your firm is saying it does not have discovery when your firm should have discovery, because you have a firm. The attorneys work underneath the umbrella of that firm, and all that discovery should be there. All right, thank you. Is there anything else? Thank you.
Thank you.
Hello, how are you doing? Yes.
It's a lovely day, Judge.
Yes. All right, we have a violation report. Your client missed a setting, well, an appointment with pretrial services.
Yes, Your Honor. I tried to contact him.
Everyone, will you all please whisper? But if you're not going to whisper, bring that same level of tone when you're before the bench so I can hear you. Yes.
I finally was, the numbers that we had, the pretrial had was his mother's telephone number. She works. I was able to call early enough yesterday that I finally got a hold of her.
Here's the heart of the case. The defendant missed a pre-trial services appointment. His excuse? Basically, my bondsman didn't tell me. But Judge Boyd shuts that down instantly. Why? Because when you're 21 years old and facing charges this serious, your freedom is literally on the line, and the responsibility is yours. Judges hear this excuse constantly, and Boyd makes the point crystal clear. The bondsman won't go to jail if you fail to show up, but you will. This is one of those make-or-break teaching moments in court. So let me ask you, do you think the judge should have been stricter here, or was the warning enough?
Apparently, Mr. Vasquez was not staying at the home. Are you staying somewhere else?
No, you, sir.
Yes. So I don't know if she didn't understand who the numbers were. He's been reporting to his bonds person. Nobody ever told him. Your Honor, I would ask that he be allowed to go now that he understands he has to go to pretrial and his bond people.
How old are you?
I'm 21 now.
All right, so you're 21. Under the eyes of the law, you're an adult.
Yes, ma'am.
You need to be responsible for, one, your own case as far as showing up. I don't know why. And when I was a defense attorney too, people would say, well, my bondsman never told me. Well, your bondsman will not be going to jail if you don't show up. Do you understand?
Yes.
So with this pretrial services, you need to be in contact with them. Do you understand?
Yes.
All right, just have a seat. Ms. Ferguson, can you have his pretrial services officer zoom in? We're going to have his officer zoom in so they can have all of your contact information. Do you understand?
Yes, ma'am.
All right, so just have a seat.
May I be excused, Your Honor?
Yes.
Thank you. You don't need me for that. Thank you.
Attorney on Johnny Ruiz Jr. I think it's criminal trial division, collision involving death. Yes. All right, so I know there are probably still some outstanding discovery. Can someone tell me what's maybe outstanding? Do you have all of the medical? Do you have the autopsy?
I do, Judge.
All right, is there any outstanding?
Not that I'm aware of at this time.
All right, so this is what I'm going to do. This is a first setting case. I'm going to set it in 30 days for you to make sure that you have all of the discovery. And then on that day, if you have all the discovery, I'm going to want an acknowledgement of discovery.
Understood.
All right, Ms. Ferguson, I need a 30-day reset on Johnny Ruiz. State you're excused.
September 30th.
All right, we're going to come back on September 30th. All right, Mr. Ruiz, when you come back to court, No t-shirts, you understand?
Yes, I saw the last one. I do apologize. I'm nervous and I just wanted to feel comfortable.
Oh, no problem. Here's the thing, unless somebody tells you what you don't know it, right?
This moment actually shows a softer side of Judge Boyd. When the defendant shows up in a t-shirt, the judge doesn't explode. Instead, he turns it into a teaching opportunity. Courtroom appearance matters. Juries, prosecutors, even the judge himself, they all form impressions the second a defendant walks in. But Boyd doesn't demand Armani suits or polished shoes, just respect for the process. And honestly, that's powerful. Sometimes judges are as much teachers as they are decision-makers. Do you agree with Boyd's approach here, or should he have come down harder on the dress code violation?
And so I always tell people it doesn't have to be a three-piece suit, right? Because I don't have a three-piece suit hanging in the closet, although I would like one, but I don't have one hanging in the closet. So,
Understandable.
all right. So once you sign the reset form, you're excused. So what's going to happen? We're going to come back on September 30th.
Mhm.
On that date, your attorney is going to let me know if he has all of the discovery. If he doesn't, hypothetically, let's say he's missing a medical report. He'll let me know he's missing a medical report. Then we'll give a reset date for him to make sure he has that, and the state turns it over. I want to make sure that he has all of the discovery so we can proceed.
Yes, ma'am.
All right. Do you have any questions about the process or anything? All right, just take a seat. They're going to give you a reset form, and once you sign it, you're excused, and make sure you put your email if you have one on the reset form, okay?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
And to think, you almost were going to leave this case. See, attorneys do work hard, you understand?
Yes, ma'am.
And I still remember you maybe not wanting to speak to your attorney.
We got off on the bad foot.
Well, I mean, you got off on the bad.
I did, yes.
Yes. All right, so the state has filed a motion to dismiss for further investigation. What that means is maybe it's going to come back, maybe not. I don't know. You understand? Defense, you have no objections to the court signing the dismissal?
No, you're not.
All right, you know what happened to cause you to be in this situation? Whatever happened, don't let it happen again. Because
ma'am.
this case, 5 to 99 years your life, okay?
Yes, ma'am.
All right, here you go, counsel.
Maybe excuse, Judge.
Yes.
Thank you.
Thank you.
And there you have it. Another explosive day in Judge Boyd's courtroom. We saw excuses, attorney confusion, missed hearings, and even a t-shirt dress code lesson. Through it all, Judge Boyd stayed firm. No more stalling, no more excuses, and no more blaming others. The big takeaway? The justice system demands accountability. From defendants, attorneys, and everyone in between. What do you think? Was the defendant genuinely confused, or just trying to buy time? And do you think the judge struck the right balance between tough love and fairness? Let us know in the comments below. And if you found this breakdown as wild as we did, make sure to smash that like button, share this video with your friends, and don't forget to subscribe for more jaw-dropping courtroom moments. Trust me, you don't want to miss what Judge Boyd does next.